Hello, everyone. Welcome to the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and I'm thrilled to have you with us today. We're here to empower women who value their health, wealth, and the legacies they're creating. This podcast delves into a diverse range of subjects encompassing finance, law, mental and physical health, and beyond. Our commitment is to furnish you with invaluable insights, engaging expert interviews, and enlightening episodes that address your questions on wills, estate planning, and probate matters. Remember, this is your community, and we want to hear from you. Engage with us, ask questions, suggest topics. Let's build a dialogue. Reach out to us on social media or leave us a comment below. Your input fuels the conversations we have. You can find all of our episodes on YouTube, Spotify, and Apple Podcasts. Be sure to subscribe and stay tuned for our upcoming content. We appreciate your support, and if you enjoy the podcast, please consider leaving us a 5-star review. Your review helps amplify our reach and brings our content to more listeners. And now, on with the podcast. Have you ever wondered what really happens if you don't have a will, or whether the one you have is truly enough to protect your family? In Smart Estate Planning Starts Here, Key Lessons About Wills, we're bringing together some of our most important mini lessons on wills into one powerful, easy-to-follow segment. If you've ever questioned whether you really need a will, worried about common mistakes, or wondered how to make sure your loved ones are protected, this episode was made with you in mind. We're breaking down the essentials, clearing up the myths, and giving you the clarity you need to make confident decisions about your legacy. Let's dive in. One of our subscribers asked if it's selfish not to create a will. Now, whether or not it's selfish to not create a will depends on your individual circumstances and the impact it may have on your loved ones after you pass away. Well, a will is a legal document that outlines your wishes regarding the distribution of your assets, personal belongings, and responsibilities for your dependents. It can help avoid confusion, disputes, and potential legal complications for your beneficiaries. By not creating a will, you might leave your loved ones in a challenging situation, as your assets could be distributed according to the laws of intestacy in your state. Now, this might not align with your actual desires, and it could potentially lead to disagreements or strained relationships among family members. So having a will allows you to make your intentions clear and ensures that your assets are distributed according to your wishes, which can alleviate stress for your loved ones during an already difficult time. And it can also provide peace of mind, knowing that you've taken care of your family's future and safeguarded their well-being. So creating a will can be seen as an act of thoughtfulness and consideration towards your loved ones to have one in place. Now that we've taken a closer look at whether it's selfish not to create a will, let's zoom out for a moment. It's hard to make informed decisions about your legacy without understanding the foundation. Before anything else, you need to know what a will is, what it does, and why it serves as the anchor of your entire estate plan. So let's shift gears and break it down clearly and simply. Welcome to Wills 101. Now, without a will, it's unclear who will manage your estate, make decisions, or care for your minor children when you've passed away. This uncertainty can lead to unnecessary stress and challenges for your loved ones. A will is more than just a legal document. It's your voice, ensuring your wishes are honored and your legacy is protected. With a properly crafted will, you can designate a personal representative. That's what they're called here in Maryland. In other states, you might know them as an executor. And that's someone you trust to manage your estate and carry out your instructions. You also direct the distribution of your assets, deciding who inherits what, whether it's family, friends, or meaningful causes. Also, you appoint guardians for minor children. One of the most critical decisions for any parent, ensuring their future is in trusted hands. Now, let's clarify some common misconceptions. A will does not avoid probate, but it makes the process a bit smoother by giving clear instructions to the court and your loved ones. And without a will, Maryland's intestacy laws decide who inherits what from your estate. And those decisions, those guidelines may not align with your wishes. So it's essential to keep your will up to date. First of all, to have one. And then if you do, keep it up to date. Major life events like marriage, divorce, the birth of a child, or acquiring, new assets are reasons to review and possibly revise your plan. Remember, creating a will isn't just about wealth. It's about protecting your family, your values, and your legacy. Do not wait for tomorrow to secure what matters most today. Understanding what a will does is essential. It's the foundation of smart estate planning. But even with the basics in place, many people still fall into avoidable and sometimes costly pitfalls. These mistakes can undermine your intentions, create confusion for your loved ones, or even trigger unnecessary legal battles. Before you move forward, it's important to know what to watch out for. Let's break down the top 3 will-related mistakes you should be intentional about avoiding, and why steering clear of them can make all the difference for the people you care about most. Number 1, procrastination. The first and perhaps the most common mistake is procrastination. We all think we have time, but life really is unpredictable. Creating a will is not about tempting fate. It's about being responsible and ensuring that your wishes are known and respected. The second mistake, lack of professional guidance. The second mistake is attempting to navigate this intricate world of wills without professional guidance. Estate laws are complex and vary by jurisdiction. Seeking advice from an estate planning attorney ensures that your will is legally sound and tailored to your unique situation. And then the third mistake is the failure to update. Life really is dynamic, and so should be your estate plan. Births, deaths, marriages, divorces, and changes in financial status can all impact your intentions and your estate plan. Regularly reviewing and updating your will ensures that it accurately reflects your current wishes. I want to share a story with you about this last mistake. I had a client, and I say had because this person is now deceased. I had a client who met with me to update his will and other estate planning documents. The original will, the will that he had, was more than 20 years old. At that time, he was not married to the now surviving spouse. He was unmarried, and he had 3 adult sons. Sadly, approximately 1 week after he met with me to update his plan, he died. And the only will, the only valid will in existence is that 20-year-old will that I mentioned, that didn't mention the current spouse and made no provisions for her. So when I tell you that not updating your estate planning documents can have disastrous consequences, here is a real, sadly, real life example of that. Now that you know how to steer clear of the biggest will-making mistakes, it's time to level up. There's one often overlooked element that can make your will clearer and more effective for the people you love: specific bequests. Let's take a closer look at why specific bequests matter and how they can transform your estate plan. If you don't have specific bequests in your will, your estate plan might not be as effective as you think. So a specific bequest is a gift that you leave someone in your will, such as a piece of jewelry, a sum of money, or any particular item that you own, right? Now, you might wonder, why is it important to outline specific bequests? Well, think of your will as a detailed map of your life's treasures and how you want them to be shared with your loved ones after you're gone. Now, if you're thinking about creating your will, here are 3 reasons you need specific bequests. Number 1, specific bequests allow you to ensure that cherished items, whether they be heirlooms, pieces of art, even your beloved pet, go to the individuals or organizations you feel would appreciate them most. For example, if you have a family heirloom, like your grandmother's ring, you might want to leave it to a particular family member who shares a deep sentimental connection to it. By making it clear in your will, you avoid potential disputes among relatives, ensuring that your wishes are honored precisely as you intended. Number 2, specific bequests can provide clarity and reduce confusion. When your will explicitly states who should receive what, it minimizes the chances of misunderstandings. This clarity is not only valuable for your beneficiaries, but it also helps the personal representative of your will manage your estate more efficiently. And lastly, number 3, specific bequests can be a way to leave a lasting legacy. Maybe there's a charitable organization you've supported throughout your life. By including a specific bequest to this charity in your will, you continue to support a cause you care deeply about, making a positive impact even after you're gone. So remember, specific bequests are more than just a legal formality. They are a powerful tool for preserving your wishes, minimizing conflict, and leaving a lasting legacy. So take the time to think about the special items and causes you hold dear, and consider making specific bequests a part of your will. Speaking of important decisions, there's another choice in your will that carries enormous weight: who will serve as your personal representative. That's the person responsible for managing your estate. Before you decide to name 2 people for the job, there's something you absolutely need to understand. Choosing what are called co-representatives may feel like the most diplomatic or fair option, but in reality, it often creates more problems than it solves. Let's break down why this well-intentioned idea of having co-representatives can actually work against your wishes. Some of my clients have expressed their wish to appoint 2 of their children as co-representatives in their will. The main reason they provide for this decision is their concern about avoiding any potential hurt feelings among their children. By naming both children as co-representatives, the clients ensure that neither child feels excluded, especially in cases where they have 2 children. Now, having co-representatives, personal representatives in a will can sometimes introduce complications and potential conflicts among the individuals involved. Now, while there are situations where it may be appropriate to have multiple representatives, here are 3 reasons why it might not be advisable. Here we go. Number 1, communication and consensus. Co-personal representatives have to work together to carry out the wishes of the deceased. Effective communication and consensus on important decisions becomes crucial. If the appointed individuals have difficulty collaborating or coming to an agreement, it can impede the smooth administration of the estate. Number 2, unequal contributions or conflicts of interest. In some cases, co-personal representatives may have different levels of expertise, availability, or commitment to the responsibilities involved. Now, this discrepancy in contributions can cause friction and undermine the efficient administration of the estate. Also, conflicts of interest can come up if co-personal representatives have personal interests that can conflict with their fiduciary duties. And then lastly, number 3, decision-making delays. Co-personal representatives must jointly make important decisions regarding the estate. Disagreements or difficulties reaching a consensus may lead to delays in executing the necessary tasks and distributing assets to beneficiaries. This can prolong the probate process and create frustration for beneficiaries. Now, an alternative to having co-personal representatives is naming successor representatives. In other words, a backup in case the primary representative cannot serve for some reason. We never want to make estate planning decisions out of guilt or obligation. Consulting with an estate planning attorney can provide valuable guidance in making these decisions. Finally, while a will can be the foundation of your estate plan, it's far from the whole story. Many people think a simple will is all they need, but that misconception can leave major gaps in protection. A will only takes effect after you pass away. It doesn't address what happens if you become incapacitated, how your assets are managed during your lifetime, or whether certain property even goes through probate. Without additional documents and planning, your family may still face uncertainty, delays, and unnecessary conflict. In the next couple of minutes, we'll cover 1, what a will actually does and doesn't do. 2, why a will alone isn't enough to protect you and your family. And 3, the key elements of a comprehensive plan that go beyond just a will. Now, first, a will is an important document. It directs how your assets are distributed after you die, after you pass away. But here's a catch. It doesn't help you avoid probate, which can be time-consuming and costly. And second, a will doesn't protect you while you're alive. If you become incapacitated, your loved ones might struggle to make decisions on your behalf without additional documents in place, like powers of attorney or an advanced healthcare directive. That's why a holistic estate plan, one that includes powers of attorney, healthcare directives, and so forth, is essential. It ensures that you remain in control, protects your loved ones, and guarantees your wishes are followed, no matter what happens. Today's episode walked you through the essentials of wills. If there's one takeaway, it's this: having a will is not optional. It's the foundation of your estate plan, a reliable way to protect the people you love, and one of the most powerful tools you have to ensure your wishes are honored, both in life and beyond. Avoiding the topic doesn't make life easier. Taking action does. And you don't have to do it alone. We're here to guide you every step of the way. I'm Elsa W. Smith, your Maryland estate planning attorney, and you've been listening to the Wills, Women, and Wealth podcast. Today's episode was Smart Estate Planning Starts Here: Key Lessons About Wills. If you found this episode helpful, share it with someone you care about. Remember, one of the greatest gifts you can give your family is the peace of mind that comes from a thoughtful plan. Until next time, stay informed, stay empowered, and take control of your legacy.